Most likely the mid of December, that's when we're going to do the conclusion.
Okay.
Yeah, it's at the draft stages.
So if there are issues that require further scrutiny or special audit, we might want to ask you to consider them in your ongoing audit or to treat them as prior year matters so that the report that will be coming for 2023-2024 should capture the areas that require further clarification. Okay, so we may proceed.
Chair, before we proceed, Chair, I wanted to bring an objection on the, ongoing on the debate of the report. Yes, we know we got the invitation and we have done our bit, but there is constitutional requirement, and the court have declared themselves on the constitutionality of the report that we're going to discuss. And there is a ruling, Chairman. And this ruling abides because we are dealing with issues of the Constitution, as it were, both at the County Assembly and national and the Senate, as it were. Therefore, Chair, there is a ruling by the court that we may not even consider what we are discussing now, as it were. And these are ruling that was given by Judge Nyaga Jairus on 1st October 2024. And the Chairman, the ruling here is a declaration was made or issued that the constitutional timelines spent out in Article 2294 and 9 of the Constitution and Section 48 and 50 of Public Audit Act 2015 are mandatory and must be complied with. This is a ruling, Chair.
Could you give us a citation?
In fact, Governor, do you have copies of that decision for the committee?
Yes.
Because we would like to read with you as well.
Yeah, because Jairus Nga has made a lot of landmark rulings. He was part of the BBI bench,
Yes.
so we need to be specific. What is the citation?
Yes.
And so that we are sure that we are talking about the same things.
I can provide it, Chair. You can, I give this one. Chair, and I've marked out. This one can, as copies are coming, but this one you can be given, Mr. Chairman. And I want.
Can you relate it to what we are doing? And because I want to understand what you are objecting to.
Chairman, allow me to give my the legal advisor, legal direct, the AG, SC to work on it, so that we can be able to understand exactly what are we doing, what are we not supposed to do as a people.
We shall, just as we usually do in even in other matters, including impeachment, etc., we shall limit that discussion on preliminaries to 10 minutes. So you have 5 minutes to state what your problem is, and within the next 5 minutes, we shall make a determination.
Maybe, Chair, as the Governor allows the County Attorney to, should we take the County Attorney under oath so that, or is the County Attorney speaking through the Governor, say that if there any adverse ruling to that, maybe you can guide so that the County Attorney speaks as the County Attorney or through the Governor, so that when we are getting and writing submissions, we are writing through the Governor or as the County Attorney, because in any cases, the county officials have taken oath, especially when they are giving evidence, which has serious magnitude as we are about to do, because the decision will come out of this ruling by the Justice Nga will have serious ramification, even in the report writing and the operations of the committee and the entire Parliament. I thank you, Chair.
Governor?
Chair, I've taken the oath. You will do it through me. Yeah.
Can you proceed?
Thank you, Chair, through my Governor. The objection being raised is breach of Article 229, Sub-Article 4 and 8. the two sub-articles of the Constitution relate to timelines given to the Auditor General within which to audit and submit accounts of county governments. Let me read. The section is in one line. It's in mandatory terms, and it reads that within 6 months after the end of each financial year, the Auditor General shall audit and report in respect of that financial year on the accounts of national and county governments. That is sub-article 4 of 229, read together with Article 229, sub-article 8. I can read it. It's in another one line, which says, within 3 months of receiving an audit report referred to under subsection 1, Parliament or the relevant county assembly shall debate and consider the report and take appropriate action. So the net effect of the two sub-articles is that the Auditor General ought to have completed and submitted the audit report of the county government of Kisii by December, and that within 3 months of submitting that report, the Senate here ought to have deliberated and determined these proceedings.
So who do you have a problem with?
The evidence I have that I can rely on.
Which constitutional entity do you have a problem with? Which constitutional entity is in breach of the Constitution? In this case, in your submission.
I want to believe both or either, and under the constitutional provisions, it doesn't matter whether it's both or either, if at least one is in breach.
What has the Senate breached as far as the Constitution is concerned?
229(8) requires that within 3 months.
Can you read it verbatim?
Council, as you prepare to read, you will also address us on retroactive applicability of that decision. You will point us to the paragraph where the judge says that all previous audits are now declared illegalities.
I think let's first stick to, because here you are at the Senate, I am not going to answer for the Office of Auditor General. I'm going to take responsibility for the omissions or commissions of the Senate. So read 2298.
It says, within 3 months of receiving an audit report referred to under subsection 1, Parliament or the relevant county assembly shall debate and consider the report and take appropriate action.
Where has Parliament breached that provision?
The invitation we received, the first invitation to deal with this.
Who tells you that that invitation was a first instance where Parliament was dealing with this report? Have you looked at the covering schedule? When was this report tabled in Parliament?
Well, you said...
When was the report tabled in Parliament?
I don't have the evidence.
If you don't have that, then you are engaging in speculation, my friend.
That would deal with 2294 concerning the timelines within which the...
No, Wakili. If a matter is expressed in terms of a time period, if you do not know the start date, can you really talk to us about breach of the Constitution? You have said yourself you don't know when the reports... Just a minute.
I have one...
Do you know...
Order, Wakili.
Do you know when the reports were tabled in Parliament? Yes or no? It's a simple question.
I don't, and that is
then
why
therefore you cannot know whether it is out of time if you don't know the date in which it was tabled.
That is insofar as you're dealing with the...
Correct, and that is the question the chair is asking you.
Let me clarify this, because this is a no-brainer. I see where you guys are going to, but we are not going to allow you to go there. This report for the year ended 30th June 2023 was laid on the table of the Senate by the Deputy Majority Whip on 21st of March 2024. Was that within the 3 months required of Parliament, according to Article 2298? Yes. What does tabling mean? It means the matter was brought before Parliament. What does the Constitution require us to do? It requires us, within 3 months after receiving an audit report, Parliament or the County Assembly shall debate, consider the report, and take appropriate action. When this report was laid on the table on the 21st of March 2024, the appropriate action that Parliament took was to refer it to the Public Accounts Committee. The Public Accounts Committee was then mandated to look at the issues, to investigate the issues, and to bring back a report. What has this Senate done that is outside the Constitution if the tabling and decision was made on 21st of March?
Now, the compliance within 3 months.
Was 21st of March within 3 months?
I'm referring to the proceedings before you.
This is the appropriate action that is subsequent to the decision of 21st of March. You should have done your homework, my friend.
Chair, also.
And